Yes, welcome to the No State Project here on my YouTube channel. Of course, No State Project. Glad to be with you here for live episode 79 from the fortified compound in Mesa, Arizona. Our show was brought to you today by Jan, the dude, and Don. I also do appreciate the support, of course, and brought to you also the show brought to you by Bill in New Hampshire and our friend Dan. And a lot of stuff to get to today. I do my best to get to everybody. But some of the things I didn't get to the other day, just an update, that Dallas police officer, they have released her name. It is Amber Guyger, 30. She was arrested a few days ago for manslaughter because she claims to have gone into the wrong apartment and she wound up shooting dead the... it's just a tragic story. His name was Botham Shemjeen. She wasn't arrested at the scene of the crime because she's a police officer. There's a double standard. Police don't get arrested right at the scene. They're allowed time to formulate their question, their answers and whatnot. And see, the little people like me, we'd get arrested. We would be arrested at the scene of the crime. But, being one of the king's men has its privileges there. It's good to be one of the king's men. Shockingly enough, she has been charged. She's out on $300,000 bail. And we'll see what happens. So Lee Merritt, a lawyer for Mr. Jean's family, was saying that we don't want it lost on anyone that had this been a regular citizen, she would have never left the crime scene. Of course. Absolutely. Absolutely. So, hey, it's good that we've got something in the right direction. Now, whether they're going to actually indict this police officer is another story, or they could just file a criminal complaint. And whether she is actually convicted, that's another thing. Yeah, but Mark, isn't everybody presumed innocent until proven guilty? Well, yeah, but with cops, juries don't seem to give a damn. It's all for show. It's just to to kind of placate the community. And we're doing something. We put them on trial. That's not something that always happens. That's why Slager over there on the East Coast, North Carolina, I believe it was, shot a man running away from him in the back and then lied, saying he feared for his life because he was reaching for his gun. There is actually video footage of him planting, not only shooting, and then a nonviolent. Some was saying he was running away. So not only did he shoot a man in the back like a gutless coward, he was on video planting the evidence. And that video was not enough to convict him. You couldn't even get him for the felony of lying on a police report. So, yeah. I started mentioning last week, and by the way, this is actually this happened in Dallas, Texas, for those who are not familiar. And what I was talking about last week about this dog and pony show, which all the confirmation hearings are for, a justice of the Supreme Court or whatever it happens to be, a cabinet member. If you want a good laugh, watch Senate confirmation hearings. They're a joke. There's no way that anybody can take these things seriously. It's all for show, just like elections. And so here you've got a slimy lawyer named Brett Kavanaugh, who is a lifelong politician, bureaucrat. That it was okay for Bill Clinton to have to answer a subpoena. And he knew that according to Bill Clinton, even though he was president, still had to answer a subpoena. And yet when he's asked at the Senate confirmation hearings last week, if the president has to respond to a subpoena, he goes the dick route. Now, he should have been held in contempt of the Senate here, for whatever that's worth, to pull such a dick move. And I will say that the senators could have been a little bit more firm, and they could, because he was saying that it was a hypothetical. But you actually believe that, and I'm not a fan of Bill Clinton. You actually, you see, Kavanaugh was on the Ken Starr team that was investigating Clinton's back in the late in the 90s. He didn't see any issue there with Bill Clinton answering a subpoena. So when asked if a president has to respond to a subpoena, he said it was a hypothetical he couldn't answer, which is, of course, a dick move. It's not a hypothetical. See, this is what I would say to somebody like that. And this is what you should do anytime some lawyer or politician refuses to answer a simple yes or no question, saying it's a hypothetical. What if I was to burn your house down 5 years from now? Would that be wrong? Are they really going to say, well, that's a hypothetical? What if I punched you in the face right now? Huh? What if I just cocked back and punched you right in the mouth? Is that wrong? It's a hypothetical because I'm not. Oh, you see, yeah, he can't actually give an answer until it happens. No, dick move, dick move. All it is a gutless coward on display on national television, refusing to answer a question, and he should have been roundly mocked. Not a hypothetical. Of course, the senators could have just said, does the law require a sitting president to respond to a subpoena? What is he going to say there? It's a hypothetical to say what the requirements, what the laws actually say? Does it require A? Well, it's hypothetical. Can you see how these politicians are gutless cowards? Not a hypothetical. Even so, let's say again, if somebody was to fly a plane into a skyscraper with the intent of causing damage, would that be an act of terrorism? Well, it's a hypothetical. I can't really answer. Dick move. You're talking to somebody who just does not want to be held to any kind of account for his opinions and what he believes. It doesn't matter if he is going to be a judge. And the whole point is supposed to be, what are your views on this? It's a hypothetical. So just know, anyone throws that out at you, they're just being a dick. They just don't want to answer the question. So yeah, you can usually just give them an analogy, or you can change the form of the question slightly. But chances are you're not going to get an answer because they don't want. Look, someone like Kavanaugh's not stupid. Most of these judges, lawyers, and prosecutors, they're not stupid. They're servile. They're horrible people. They're criminals, part of a criminal organization. But they're typically not stupid. So they know what you're asking. That's why they'll say, I know where you're going with this. Why don't you just answer the question? I mean, honestly, do you think you and I can get away with that kind of crap if we're being questioned by the police or a prosecutor? Could you imagine, that they would, well, it's a hypothetical. License and registration, please. That's a kind of a hypothetical. I don't think I need to answer that question. And where did it come out that you don't have to answer hypothetical questions? That you're so absolutely privileged that you don't have to answer a hypothetical? Oh, so if I take a bat to your car 5 days from now, is that wrong? It's a hypothetical. I can't answer that. Let's see when you do it. Who talks like this? Hey, I tell you, it is quite something. And one other thing I want to talk about here, I know we're getting lined up with calls, so bear with me. I was just looking at something, and the Great Awakening Reddit subreddit has been banned, and a whole bunch of other ones. And I got to tell you, I don't know as much as I probably should, but I think I have an understanding of where these people are coming from. This whole QAnon. I can't believe that after Pizzagate, anybody would take seriously what is on 4chan. They're obviously trolling. And it's 4chan. Is that a clue? And the idea that somebody it's supposed to be that QAnon is this somebody with a security clearance high up in the United States government. who's trying to expose the deep state, and he's trying to work, and that Donald Trump is actually working with Robert Mueller to and Jeff Sessions, and that there's something like 10,000 sealed indictments, and that there's going to be arrests any day now, and Obama's going to be arrested. He's been indicted, and Hillary butter emails. Clinton is going to be indicted any day now. If there was such a thing as the deep state, I would imagine that if this guy really was a high security clearance individual trying to bring about this great awakening and these mass indictments and whatnot, that somebody within the deep state, within the CIA, could just take this guy out. They'd be able to figure out exactly where the signal, and they'd be able to take him out. They knew how to induce a heart attack from it was in the Senate hearings back in the 70s, that the CIA had a heart attack gun. They can take out anybody they want. If anyone is truly a danger to them, just take them out. It is beyond that anybody could take this QAnon stuff seriously, and Alex Jones, that take Alex Jones seriously. It is just beyond. It can only be just a serious case of lack of critical thinking skills, and that's why things like this would take off on 4chan or Facebook, because I got a confession to make. I went against my best judgment. I actually posted a response on Facebook, and it is incredible to me how people will dig their heels in, that no matter how wrong they are on the most insignificant, no matter how wrong they are on the most insignificant things, a post on Facebook. If you post something on Facebook and you're wrong, just, all right, correct it. But to dig your heels in and start, so what it was, and you got to expect this. You cannot have a rational discussion on pretty much any topic on Facebook, YouTube, or Reddit, or one of you're just not going to happen. It's not going to happen. It is especially true with the subject of anarchy and veganism. You can even have anarchists, and the moment you start bringing up veganism, all of their rational, concepts and ideas and whatnot, all their logic, that's gone. They are so conditioned, and I was at one point, but but not like that. I was able to listen to the evidence and change based on the evidence. And it's incredible. Anytime veganism is mentioned, people just thought that with the hate. So what this guy did, and he claims to be an elite powerlifter, posted stating that there are no elite bodybuilders and strength athletes that are vegan. None. Zero. Now, you can destroy your own body through eating meat and completely ignore the ethical part of it. You can do that. You can make a choice to damage yourself and to damage animals because you don't care. You think animal cruelty, way to go, you're good with it, okay? But if you post something there that's wrong, and I know that this is on me, I shouldn't have posted anything. So, but what I did was I posted, I quoted what he said, what he wrote, that there are no elite bodybuilder and strength athletes who are vegan. And I posted a short video of Kendrick Ferris. Kendrick Ferris is the only male American weightlifter to have qualified for the 2016 Olympics. Okay? That is elite. If you make the Olympics, you are at the top of you are elite. Whether you win is not relevant. You are elite. And then I also posted a short video of Patrick Baboumian, who not only has a Guinness Book of World Records for the most weight moved by a human being, vegan, but he also competes as a strongman in Europe and has several European records, such as the log lift. And you get the same stupid responses. And so he initially comes back with what federation? And there are so many federations that anyone could break a record in any federation, because there's just so many federations. I mean, it was the Olympics, and it's like moving the goalposts. Okay, it's not that he has the record; it's that he qualified for the Olympics. He does have the American record for weightlifting, and there's not nearly as many weightlifting federations as there are powerlifting federations. Because here's the thing, and I consider myself an Olympic lifter and a powerlifter. Powerlifting generally is kind of a joke because of all the drugs and all the equipment that's used. Okay? Raw federations, no, I consider that a sport. But when you're putting on shirts and equipment, please. But there's not that many Olympic lifting federations. This man qualified for the Olympics, and regardless of the strength sport that it was, that's elite. So to point out what federation, no, the fact is they are, Patrick Baboumian and Kendrick Ferris are both world-class elite athletes and are vegan. So it defeated his stupid claim, but he keeps digging his heels in. He just can't admit that his statement was wrong. Just because he doesn't know any elite lifters that are vegan doesn't take away. So then he turns around and says, well, Kendrick didn't win a gold medal in the Olympics. That's not the claim you made. The claim you made was there are no elite strength athletes that are vegan, and clearly that is wrong. But I take it on myself that I went against my judgment. Don't post on Facebook, because it is a horror show for any kind. If you can't do it. You absolutely cannot do it, and I gotta keep to that. So that is really unfortunate, because nothing's going to be accomplished. But you'll just keep moving the goalpost instead of just admitting, oh, I probably shouldn't have done that. I shouldn't have been so arrogant as to make such a statement, and then be arrogant to dig my heels in and not admit, oh, okay, all right, I didn't do my research. Well, whatever. It's not a big deal. It's just not a big friggin' deal. And there are elite athletic vegans in all sports. Serena Williams, the embarrassment recently, she's still one of the top tennis players in the world. Vegan. How many NFL? So look, you got to drop this nonsense. It's just not factually accurate that you cannot be a world-class athlete without eating meat. Look, there's too much evidence. It's just like trying to say, well, the laws do apply. No, there's just no evidence, and the evidence against that is just too high. Again, I have the idea that there's going to be a lot of equivocation. We're going to get that. I haven't seen, I've only seen a little bit of the evidence of the equivocation that one of these critics is using to try to show that these laws do apply. Yeah, you can equivocate. You can say whatever the hell you want. You know, it doesn't mean it's true. So I will again do my best to stay off of Facebook. I don't even comment on my own videos, for heaven's sakes. Why? Because you cannot have a rational discussion on social media. You can't. That's why I always make a point. Call the show. If I'm saying something that's wrong, let's do this in real time. If you're going to be a dick and you're going to talk over me and you're not going to answer the questions, you're not going to present the evidence, you just want to troll and you want to dig your heels in and be a dick, well, yeah, I'm going to drop you from the show. There's no reason to keep you on. But if you want to have a rational discussion, yeah. 218-632-9399, 218-632-9399. The passcode is 2020 with the pound sign. And before anyone says I'm not capable because I am emotional, just listen, you know, there's tons of calls on the website. I spoke with a law professor in British Columbia, Robert Diab. Wasn't a crossword. Neither one of us interrupted each other because it's a two-way street. If you're going to be a douche and you're just not going to shut up when someone's talking, well, yeah. Of course, that you're the problem, though. But if you want to call and have a rational discussion, which we do 99% of the time here on the show, call, even with someone who disagrees with me. So, but let me put the the headphones on here, and we will get to the calls because that's what we want to do here. We've got Anthony in Texas. Anthony, welcome back to the big show.
Hey, Mark. How are you doing?
I'm doing well today. You got good news for me?
I wouldn't say it's really great news. The arraignment went fine in the sense that I didn't get arrested. I didn't get threatened with contempt, but the judge, it kind of went as expected. He went on lengthy monologues about the process. He pretty much failed to answer all of my questions.
Okay, but let me ask you this, Anthony. Did he actually answer some questions?
He did actually. I was surprised. He said a few things which were surprising, and then when I tried to confirm them, he backed off. The first one was he said that I kept pressing him what facts are on the record which establish and prove that the court has jurisdiction at this point. And he said, well, there are no facts on the record right now. I said, he of course took another 60 seconds of talking, but I said, hey, wait a second. Did you just say that there were no facts on the record at this moment that prove jurisdiction? He's like, well, no, I didn't say that. What I'm saying is I'm here to take your plea, and it sounds like you're refusing the plea.
Oh!
So, at one point, I even objected. I said, objection, I'm not refusing the plea. All I need to know is the answer to a couple simple questions. And he said, you can't object. This is an arraignment. And so
wow. Well, hold on, Anthony. We just can't object. This is an arraignment. Yeah, I'm going to have to go and disagree with you there. Can you give now? What court did this happen in?
This is the Houston Municipal Court.
Houston. Are you comfortable giving the judge's name out on the air?
Yeah. Let me see. Judge Grant H. Coleman.
Grant H. Coleman. Yeah. At any time during this exchange, I'm writing down, so I'm going to get to these because I think they're important. At any time during this exchange, did Grant H. Coleman snap at you that he's not there to answer your questions?
He did not. In fact, in terms of interpersonal interaction, except for continually interrupting me to go on lengthy, irrelevant monologues, he actually had a polite demeanor about him.
See, this is very interesting because there's a school of thought there, and they're typically critics that like to post on during the live chat, which is always welcome, even if they disagree. I would say that I like the chat seems to be a lot more toned down, and it's today, but I'm not reading too much of it. But there's the idea that judges and prosecutors don't have to answer our questions. And you are now one of the, maybe of, let's say 2,000 or more, let's just throw that out, who can come on the show with personal firsthand knowledge, because I've done it myself, and report that the judge did answer some of your questions.
Yeah, not responsive, but he gave words. He said words after I asked my question.
Yeah, but the point being, he may have not answered responsively, but he did allow and answer questions. He just didn't do so always responsibly. My point here is it's further proof against this notion that newbies may hear and take as true that, oh, you can't ask the judge. Yeah, you very well can and should ask the judge questions. Because if the judge is insisting that there's jurisdiction and there's not a prosecutor there to answer what those facts are to support that, then the judge has to inform you. If they haven't told you what, let's say you're in there and you don't even know what you're being charged. Excuse, sir, I don't even know what I'm being charged with here. What's the charge? Do you really think that that due process and principles of fairness would say that and support the judge in saying, I'm not here to answer your questions, just how do you plead? Yeah, but I don't know what the charge is yet. You see, and even if it's some kind of unwritten rule that Mr. Judge Coleman just doesn't know, he hasn't gone on to my YouTube channel. Sorry. He hasn't gone on to my YouTube channel to see what the law really is about judges, answering questions, and he did that anyway. The fact is, they're human beings. They're not very nice or good human beings. They're part of a criminal organization, but you're there to resolve a problem. And the idea that to try to resolve this problem that one side doesn't have to answer any questions. I say, if it's an unwritten rule, I'm not going to follow it. And we've had too many people, well, in addition to myself, report great success because we are going and asking questions. Look, let me just go off topic just to make a point here. My grandfather died when my mother was a baby, okay? And being half Sicilian, and my grandmother was from Sicily. And there's a point to this. And the Sicilian thing was, anytime something was brought up about going out, getting the baby, getting the kids a radio, someone was, my husband is dead. He's dead. And it was an unwritten rule that I wish I had broken back then. And it was, you don't talk to grandma about Grandpa Sal. You don't do it. And so we never did. So I never got to hear anything about my grandfather because my mother was an infant. My aunt was dead, a little baby. So it wasn't until years later that I spoke to his sister that I find out some more information about him. We need to be able to break the orthodoxy and break take the blinders off. So I'm not just saying this to you, Anthony, but it's, to anyone listening. If somebody says you can't ask the judge questions, ask him why that is. Well, he's not there to answer your questions. Well, how am I supposed to be informed? Challenge us and don't take it at face value. Make them prove it. And you're now another witness with personal knowledge, unlike the police officer who they're going to get to testify against you, to say that the judge did field your questions. Didn't answer them responsibly all the way, but he did answer them. Okay, so I wanted to ask you about this, the refusing to plea. When he said it sounds like you're refusing to plea, did you object?
Yeah, I did object. He kind of laughed. He said that you can't object. This is an arraignment. And he read the first charge. He said, how would you like to plea? I told him, I don't understand the nature and cause of this action. He says, well, you have to plea. And I said, well, has a valid cause of action been filed to establish that the court even has jurisdiction in the first place? Is this a valid cause of action? And then he said, I'm only here to take your plea, but it's for the trial to decide whether it's a valid cause of action.
Wow.
Then he said, in fact, I don't know if it's a valid. He literally said, I don't know if it's a valid cause of action. I'm not here to determine that. And I said, wait, let me make sure I understand.
Oh my gosh.
You don't know if it's a valid cause of action. He said, well, no, I'm not saying that. I didn't say that. I said, those are the words you just used. You just said that, your own words. So he just kept kind of repeating himself. This
wow.
is an arraignment. I'm just here to take your plea. It sounds like you're refusing to plea on this first charge, so I'm going to make an entry of not guilty. Of course, I objected again. So
okay,
we went through all 5 charges with the same.
Wow, I do. Did you Skype me before the show? Is that you? Are you the one?
No, not this show.
Okay, all right. Someone Skyped me right before the show and they had mentioned, they were in Hawaii. They made the same mistake. I think it was Hawaii. Yeah. They made the same mistake. I don't think we ever want to say that we don't understand, because what they did to him was they forced an attorney on him because he said, I don't understand. So we want to avoid that. Okay. So what we can say when they say, when they start this refusing to plea, say, no, objection. I intend on pleading guilty. I just want to know if the prosecution has sufficient facts, to prove that there's jurisdiction to require a plea in the first place. So one of the things we can say here is, look, sir, you're here. All right. Look, you're saying you're just here to take a plea. I want to know if the prosecution has presented evidence to allow you to have an arraignment in the first place.
And I asked him too. I said, are you allowed to forcibly arraign me without a valid cause of action? He said, I'm not forcing you. He said, listen, if I didn't show up here, there would be a warrant for my arrest. He says, yeah, but I'm not forcing you. And I said, well, I'm here under the threat of force. And are you allowed to arraign me without a valid cause of action? And he started, well, the process works like this. And, a bunch of word masturbation, basically.
Yeah, they call that basically a Gish Gallop, where he just starts going, or a word salad, where he's not answering the question. He's not presenting the damn evidence. Okay. And so again, we're here, this thing that you can't object. This is another lie from the judge. And you could even be, blunt with him. Sir, are you willing to say that very clearly on the record again? I don't think the appellate panel, if this has to be appealed, I don't think they're going to agree with you that I can't object at an arraignment.
So this brings up an interesting topic. None of this was actually recorded, whether electronically or by a court reporter. So it's basically just kind of my word against his. There was a couple secretaries there, but they're not gonna remember much of it.
Yeah, but that's one of the reasons why it's important to have the unsigned plea of guilty. It's in writing, and so now if you do get a hearing or you get some discussion on the matter where the judge is saying, or the prosecutor is saying for the judge, oh, this guy Anthony's a lying SOB. He is just he's got his facts all wrong. The judge never said that. The judge did not enter a plea over his objection. The judge falsified the record by entering a plea on my behalf because it's implied that I was refusing. So even if you have no record of the judge saying those things, the fact that he entered a plea of not guilty implies one of two things. You were refusing to plea, or two, he couldn't ascertain your plea. The unsigned plea of guilty stands as direct evidence contradicting that and showing that the judge is falsifying the record.
Ooh, should I have filed that not guilty, that unsigned, with the clerk? Because I didn't file that with him. I had it in my hand. I showed it to the judge, but I didn't file it after we got done talking.
You want to ask to approach the bench so you can hand him a copy of it.
Okay, and I was right in front of them. They actually invited me up to the bench. There was hardly anyone in there, so that was nice. It was a speedy process for one.
Well, that's good. So the idea that you can't object, wrong. Absolutely, without qualification, dead wrong. If there is something that the judge or prosecutor is doing that violates due process and the process being fair, you absolutely have to object, or you can't preserve the issue for appeal. There's very limited circumstances where you don't have to object to preserve the issue for appeal. And one of them is if the judge is testifying against you. Now, it does happen. It happens all the time where the judge is offering testimony against somebody, especially, well, it happens all the time in tax cases and traffic cases. That happens constantly. Judges can't, all right. So the other thing here is, I like the cause of action here, and you did a pretty good job of backing him into a corner where he had to backtrack about the cause of action, and here I guess what you could have said. So if I sued you, you couldn't argue there wasn't a valid cause of action in jurisdiction until trial.
It's hard. It's hard to get those questions in when he interrupts you halfway through your questions and then goes on a 2-minute monologue. Because you kind of have to sit there and wait until he's done talking, because you don't want to interrupt him, of course, but not the honorable judge, the knowledgeable.
Well, we're not going to. Yeah, I get the sarcasm. And for those new listening, we don't interrupt the judge because we think he's honorable. We know he's a snake. We know he's incredibly biased against us and has no intention of being fair. We don't interrupt them as a matter of decor, that we're the professional ones, and we don't want to give them a reason to hold us in contempt or something like that, where they use it against us, where he's just being, they can honestly, well, he's just being argumentative. You may not have been argumentative, but you interrupted him, and they'll use that, saying that you were disruptive, and maybe even use that as a grounds to force a lawyer on you, which is, unless you're being charged with a pretty serious crime and you're really bad at court procedure, you don't want to have happen. So I
even asked him, I said, are you able to dismiss this ticket today? Are you able to dismiss this matter right now? And he said, no, I can't dismiss it. I'm not able to do that. And I was just taken aback. I just let him get away with that. And about a minute later, I said, wait, just to confirm, you are not able to dismiss this ticket. You do not have the authority to do that. He said, well, no, I could dismiss it, but it's set for trial. So this gets into, I don't have a pretrial. They just set me for a trial 2 months later in November. There's no pretrial. Should I make some kind of motion to do that, to get the cop there and try and get this settled before we get, you know, 7 or 12 unwilling people into a room and wasting their time?
Yeah, well, you should still do the pretrial procedure. I mean, I think it's in Texas Rule 16 that they have to give you copies. And the discovery, whether there's a rule in Texas or not, due process still requires that they give you discovery and Brady material. So even if they didn't have a formal pretrial procedure before the actual trial, Brady material still has to be given. And that, to me, in these cases, is the most important, because they have to have a witness with personal firsthand knowledge to, you know, of the matters. They have to, the cop who's charging you has to have personal firsthand knowledge of the matters they're testifying to. They're testifying that the laws apply and gave you them jurisdiction and that you violated those laws. They have to have personal knowledge of that.
So I did file the Brady request and the discovery that same day, and the motion to dismiss. And I asked them, I said, so am I going to get a response to these before that trial date 2 months from now? And he said, no, they'll probably just, the judge will rule on it directly before the trial. So it seems like I'm going to need to do something to force them to give me a response.
You can call them. And they do have to give you the discovery material. It's not that they give it to you. Well, what do you charge? What are these charges? There are 5 of them. They're traffic, right?
Yeah. So one is speeding, one is suspended license, the other is no registration, and window tinting, and then I think he came up with something else. I don't remember what the 5th one is.
Okay, so it's traffic. So, but these are obviously misdemeanors. They're charging you the crime. Mm-hmm. Yeah, so they have to give you the Brady material prior to the trial. If they don't want to give it, you know, put it out there, wait the 21 days, file a motion for prosecutorial misconduct to dismiss, and file a motion in limine. You know, that's the best we can do. As far as the judge, I imagine the way he kept on going back and forth, that he ended this proceeding by yelling, "Jobs!" Because he's sad. No, not that.
He didn't yell at all. He just.
I was making a joke.
Said, okay. Oh, okay. Sorry.
I was just making a joke there. I don't know who's good. You know, that's it. Didn't land as well as I would have liked them. Maybe someone on the chat got that. All right, but it's the flip flopping. It's saying whatever you need to say to get out of that situation, and not having a constant and then just yelling sad or jobs to end that. Well, I appreciate the call. If you have any other questions, definitely email me or call on the Saturday show. But yeah, I'd get the discovery one. You wait the 21 days, and then hit them with the motion to dismiss for prosecutorial misconduct.
Cool. That's yeah, that sounds like a plan. Thanks, Mark.
Appreciate the call, Anthony in Texas. We're gonna go to Kevin in Pittsburgh. Kevin, welcome back to the show.
Hi, Mark. How you doing?
I'm doing well. How are you doing?
I'm all right. I had my trial yesterday.
Oh, man. You got
last week.
Is this good news or bad news?
I had a moral victory. I mean, it was 4-on-1. But, I mean, I was still found guilty. But
I'm sorry to hear that.
Fun doing it.
What happened?
So we went over the discovery. I called last week. They destroyed the video evidence of the camera, the telephone pole camera that was there.
Right.
And so we went over that for like a half an hour, and they were trying to find out like exactly when the prosecutor knew, you know, got my motion for discovery and stuff, because he said he didn't get it till like the hearing I had in April or May. And then they brought the cop brought the police chief in, and the police chief whispered to the prosecutor and said, "I faxed it to you on the 27th, February 27th." So then, yeah, they told that to the judge. So it looked like he was going to let him go, but then so it looked like it was going my way. So the chief was like helping me out, it seemed like. So then looked like he was about to throw it out. He asked me, he goes, "Well, what do you want me to do now?" And I go, "Well, dismiss it." I go, "They destroyed evidence." And then he asked the prosecutor, he goes, "What do you think?" And he said, he goes, "I think he made some good points." And then, so he like took my side. He was about to throw it out, and the cop whispered in his ear and said, "The discovery motion only mentions the actual, like, where he stopped the car and the arrest." Trying trying to think, is that number 8? Regarding the stop and the arrest. So the judge, after we spent a half an hour on, he goes back, reads the motion again, and number 8 doesn't mention like the actual and where the infraction took place. So that's, and then he read number 11, and he goes, well, that seems like it's referring to Brady material, not the telephone, not the camera on the telephone pole. And so after all that, then he dismissed and said there was no discovery violation.
Wow.
And so
well,
then I brought something else up, and then he yelled, he goes, well, I said at the last hearing, only if they had the video, they had to give it to you. They don't have it, so they don't have to give it to you.
Oh my gosh. They only have to give you, wow. Wow. What a, wow. Did you get any discussion on the Brady material? Did their witness have personal knowledge of the matters they were testifying to?
No, he already denied the Brady material last time, said they didn't have to give me any at the last hearing.
No Brady?
And
now, they saying that, that there wasn't any Brady material to give, or they had Brady material and didn't have to give it to you?
Well, he didn't say if there was any or any. He just said they didn't have to give it to me. He just said,
wow,
give you any Brady material. But yeah, the only thing he said from discovery they had to give me was the camera footage.
That is,
that,
wow. Did you, at any time through this, did you bring up whether, you know, the fact that there was no proof from the prosecution that the witness had personal knowledge of the matters they're testifying to?
Probably not till we actually started the trial and the cross-examination. I brought up that he was qualified not to give legal opinions. And
you brought that up?
At this point. Pardon me?
You brought up he wasn't qualified?
Yeah, that was before he even testified. I objected when he was for the
but
cross-examination.
the object.
But
the objection should be that the prosecution doesn't have, the rule is very, very clear. There has to be proof of personal knowledge of the matters they're testifying to before they're qualified to testify. So that's what we want to stick to. Where's the prosecution's proof that the witness has personal knowledge of the matters they're testifying to? That is, I think, a more effective objection than you just coming out and saying he's not qualified to give legal opinions. Because they're not going to say that. They're going to say he's not qualified to give legal conclusions.
Okay, I see what you're saying.
So stick to where is the proof that the witness has personal knowledge of the matters they're testifying to. Because the only way out of that is for the judge to be, to be unfair and give the prosecution a free pass and say, you can bring out that, if you don't think he has personal knowledge, bring it out on cross-examination. And I keep saying that this is unfair because there's no way in the world that you could pull a witness out and put them on the stand if you could not show evidence, proof of personal knowledge first. The prosecution would be, moving for an adjournment so he could file a writ. He would not allow it. Their head would explode if the judge allowed it. It is not fair to do that, and it doesn't cure it to go and say, well, you could just put him on the stand for cross-examination. Because the judges who do that, the judges who allow that, have no intention of holding that prosecutor's witness or the prosecutor to Rule 602 that they have to have personal knowledge. They will not do it. And that's why they come out with the same standard objection. Objection calls for legal conclusion, even though we're asking a question to elicit fact. They have no intention of being fair. It's just like when they do this, Kevin, when they turn around and say, even though, let's say you filed a motion today and you have a trial in December, motion to dismiss, and say, well, I'm not going to rule on the motion. I'll rule on the motion the day of trial. That is the same sort of douche move that when you want proof that the witness has personal knowledge. They're going to just deny it. If they had any intention of addressing the motion, they wouldn't do it the day of trial. That just means get in here. You're going to trial regardless of what's in this motion. That's why I've even had judges tell me point blank that they were going to deny a motion they hadn't even read yet. I mean, come on. Oh, okay. So you're on cross-examination with the police officer. What happens?
Yeah, the cross-examination didn't last long. I made that objection that he's not qualified. The judge yelled back and said, he is. He's only testifying that you went through the red light. So then I was asking him questions if, he made the legal determination that I violated the code. And I asked if he was qualified to do that. And there's the one that he wrote down on the ticket. And then I asked a couple of those questions, and the judge just started yelling and saying he's not giving legal opinions. He's just testifying that you went through the red light. And then so he was the judge was making the objections.
The judge did? Oh, so he's
well, he
okay.
didn't say object. You know what I mean? He
yeah.
yelled back at me. The prosecutor didn't say anything. So.
Yeah. Oh, I get what you're saying. Now the thing. All right. Let's discuss cross-examination again. Whoa. He's not just testifying about the red light. Didn't he testify that you were required to have a driver's license and didn't have one, or you were driving on suspended?
No. I mean, I didn't bring that up. I mean, I didn't ask that. He didn't.
Okay.
That didn't come up.
Well, one thing we have to keep in mind, if the prosecutor is shrewd enough not to ask the police officer questions on direct examination that require him to say you violated the law, he's already said that, which is really rare. And it's something you could bring out on cross-examination anyway. You wrote this ticket, didn't you? Can you tell me what charge one is? Is that illegal? Is that a statement of fact, or is that a legal conclusion? Well, it's a statement. It's a legal. So you can get him to testify. But 99% of the time, they are giving this. They're repeating the legal conclusions they made at the stop. So it's fair game on cross. Even if they didn't say it on direct, the fact is their prior statements. And prior statements, things that happen at the stop, are fair game and are relevant to a cross-examination. Remember, relevance just has to relate and have some relation or have any tendency to prove the truth of a proposition. And going back to prior statements is his competency and his credibility. So the idea that he's not giving legal opinions, he damn well did before he walked in the door. They're in the record. You can hand him a copy of it. So the judge here is blatantly stepping on you and denying you effective cross-examination. So since you do have to appeal it, and I can get you a template for post-conviction relief and appeal this, but the appeal should be a slam dunk. This guy stepped all over and denied you effective cross-examination. For you not to be able to ask him questions regarding the veracity of the statements he made at the stop and on the ticket and in his police report that's a denial of an effective cross-examination. And so that should definitely be a part of post-conviction relief. It's in the template already. You just have to put in your facts, and it certainly is a part of any effective appeal.
Should I also put in the appeal about the Brady violation and the discovery violation?
Absolutely. You have to include that. So
okay.
Did he just at one point stop the cross-examination?
No, he yelled at me, told me I just had to ask questions about, actually going through the red light. And then I asked another question. When did I asked if the ticket he wrote was consistent with the Pennsylvania Constitution. And he said yes. And I asked if I violated anybody's rights. And I think that's when the judge started yelling again. He goes, that's he said something that had to do with the suppression hearing. This isn't a suppression hearing. And then he was just, he was all red. He was all fired up at this point. And I think I said I was done. I might ask another question. I think I might have brought up a valid cause of action, and he was pretty fired up. So I just said I was done.
Yeah, I understand now. You definitely, the yelling part, the fact that the judge bullied you throughout, should be considered as part of a denial and effective cross. So, well, I'm sorry it went that way, but having a judge yell, I mean, the prosecutor probably loved it. The prosecutor didn't have to do anything and make any objection. Did the prosecutor make any actual objections?
No, I don't think so. I think he likes me. He was kind of like on my side, and that's what he even said. I made some good points in the discovery motion. And whenever he did that, the cops, they threw their hands up in the air. And then like me and the judge started laughing whenever he asked the prosecutor what to do. And he goes, oh, he made some good points.
Wow. So, well, hopefully we can get this cleaned up with post-conviction relief, and if you have to still appeal. So, but you can contact me off air for those documents.
Okay, I'll do that.
Appreciate the call, Kevin in Pittsburgh. And, here again, let's put, look, it's always going to come up. No matter what happens on the show, no matter what evidence there is, there's always going to be people out there chatting or posting that I only cherry pick, I only post and discuss about tickets that are thrown out. And here, Kevin, because I can't screen calls unless you've called the show before and you're a troll. Just like when I had that little kid doing that. But here, it didn't go well. It didn't go well. So, which is really unfortunate, but he's got a lot of issues for, some solid issues for appeal that he can take up. Let's see. Oh, wow. This is a fast show today. Well, it always is. We're going to go to our last caller. We got area code 443. What's your name? Where you calling from?
I'm Chris, Maryland.
Maryland. Oh, gosh, you guys are in a line of fire right now. What was your name again?
Yes, sir. Chris.
Chris, what can I do for you today?
I just had a couple quick things for you. I used your motions in my girlfriend's hearing on the 10th, and that didn't go too well. The judge blatantly, he said, oh, you have motions here? And then he looked at him and said, oh, denied. And he kept right on moving.
Well, wait. Chris, did he actually, did it look like he actually read the motion? It is 5 pages long.
No, he spit and said denied.
So you're telling me a judge in Maryland denied a motion he didn't read?
Right.
Yeah, I would say that was a denial of due process, but maybe, I know we've got somebody here who's going to say my imaginary due process violations. Let me ask you, do you think it would be fair? You think the prosecution would think it was fair if their motion was denied without being read?
Oh, definitely not.
But when it happens to me, when it happens to you or someone else, oh, you're just imagining things. Oh, okay. Well, I'm sorry to hear that it went that way, but did you file the motion at least somewhat in advance?
The motion to dismiss, motion to dismiss and the discovery and Brady request were both filed with the court. And when we followed them, they refused to take them. They said, this is not our case number. This is in Washington County, Maryland. And they do a contract with Breckford. All the paperwork, which we did file with them, went through them as well. But got no answer. The sheriff that was in charge of it or them had signed confirmation that it was delivered to them. Luckily, I don't want to take up too much of your time. I know you're busy, but luckily the judge ended up dismissing it only on the basis that we requested the officer. We had already been there for what we assumed was going to be a trial, which was not at the last time. And that's when the judge himself requested the officer to show up in the next hearing. So that's the only reason the judge actually dismissed it, which kind of threw me for a loop because he just blatantly found it that I was telling the truth, that it was filed in the first place, and went off and right away said, oh, here it is, denied. I'm going to deny your motion.
Now,
like, how do you get around that?
Well, you're going to have to file a motion to change the judge. That's what I would do, because obviously the judge is denying it arbitrarily. This isn't a matter where he actually read it. He was first saying that the motion wasn't filed, so he could not have read it unless he was lying that the motion that the motion wasn't filed. So then he finds it. So the judge is denying it arbitrarily. Now, the motion to dismiss is based on a lack of evidence, as you know. So due process, as far as I know, and I'm not even pretending to be a country lawyer, but with my knowledge of the courts and, and due process, that if something is arbitrary and capricious, that violates due process. So that is my basis for saying that if a judge doesn't give a reason for his decision, it is unfair because it's arbitrary and capricious. Now, the judge can say, or the prosecutor, but it's not arbitrary. The fact not appearing is presumed not to exist. If he's going to say, I don't have to tell you, well, if you don't, see, even though the appellate courts, I had this as far back as Adventures in Legal Land, the appellate courts have ruled, and no, I don't have it off the top of my head, that to be able to review a judge's abuse of discretion or his rule, they have to have the grounds, or they have to just make a de novo. They can't review it. They have to do it de novo. They have to determine on their own if the decision was wrong. They don't have anything from the judge. It is the height of scumbaggery and douchebaggery to say that a judge can rule with no reason given whatsoever, and that doesn't violate due process. To say, well, he doesn't have to. No, due process requires, if an IRS agent makes a determination against you that is arbitrary and capricious and says, I don't have to give the basis of my decision, it's thrown out. It's gone. And that's like Helvering versus Taylor is one of the cases. If you can show that it wasn't based on facts, that it was arbitrary and capricious, then it has to be tossed out. Due process requires that there's evidence and a logical basis for it. So judges are not exempted from the due process clause, as far as I know. No, I think it's rational. Due process requires, that it's not arbitrary and capricious. So again, if there's a loophole that judges have to be a dick and say, well, they don't have to have any grounds whatsoever, and they don't have to tell you, that just is more evidence that the system itself is grossly dishonest. The idea. I mean, can you imagine in another profession where a doctor says, you have cancer, and if you don't pay $250,000 for treatment, you will die. And you say, how are you determining that I have cancer? I don't have to tell you that. See, but in the real world, if a doctor pulls this same dick move, then you can just say, I'm not going to pay you a cent, you shyster, you're a quack, and you leave. But judges can force you into the proceeding and then turn around and say, I can make a decision that impacts your life, and I don't have to have any reason or grounds for it? Come on. Look, look, anybody other than a shill for a dishonest system would say something like that, right? I mean, all right, but let's get this because I am pretty much out of time. So,
well, I had another quick thing. Can I
sure.
This in real quick? When he started the whole case, the whole courtroom, he went over the people, and then he said, look, if you got a ticket, you're going to pay. There's no way you get out of it. I have no control over this. You're paying. If there's a ticket, you owe the money. So
holy crap. What's this judge's name?
I believe it was Mr. Johnson. I don't remember his first name because I don't, I have no respect for these people. So I will go down to the, I'm not going to say honorable or your honor or nothing. No judge, nothing.
Just sir or ma'am. So judge, and what court was this in?
This was in Washington County District Court. And when he went up there, he did the introduction. Okay, this is how this works. You have a ticket. You're going to pay. There's no way to get out of it. There's no witnesses. There's nothing you could do to get out of it. I would definitely file a motion to change the judge because he's telling you and if you have witnesses to this, have them, I would do a supporting affidavit with that and have them say this. Yes, the judge said, if you have a ticket, you got to pay. There's no getting out of it. He's actually telling you that you cannot get a fair trial. It's rigged. And I would certainly let the county commissioners know you've got a judge here who's admittedly running a rigged court. Right. Yeah, I thought it was just funny that he said that, well, you're not getting out of it. There's nothing I can do.
Oh, my gosh.
I thought you were a judge.
Yeah, well, he's admitting it's a rigged game.
Right. When we filed paperwork too, my girlfriend asked, so is this company renting a courtroom out to you guys, or are you renting this company so you can do these hearings? They wouldn't answer her.
Wow. Well, okay, so that what I would do is file the motion to dismiss, the motion to change the judge, and I'm pretty much out of time, so I'm just going to summarize. But let me, contact me off air, and I get you a copy of that. Okay.
Okay. Well, I already got a copy of it.
Oh.
Luckily, like I said, it was dismissed because the officer did not show. But that is the only reason. If there's no officer and you don't request them, you're guilty automatically.
Oh, well, I'm glad it was dismissed. Well, fantastic.
So luckily, yeah.
Wow.
Luckily successful. Thank you, sir.
Excellent. I appreciate the call. I wanted to get into this an issue that came up earlier on the show, and Chris just reminded me of that. So I'm just going to take a moment to explain this. There are situations where what appears to be a judge cannot dismiss. And that is the case, for example, when you're in federal court. If you have a magistrate, so the magistrates operate underneath a district court judge. A magistrate is not the same thing in federal court as a judge. So you've got the magistrate and you've got the judge. The magistrate can do all the pretrial stuff. They can even conduct trials, I believe, okay? But they cannot dispose of a case. So, for example, if the IRS is hauling you in on a summons, and you file they want to enforce the summons, and you file a motion to dismiss for whatever reason, the magistrate, at least the way it used to be, I don't know if it's this way, but it could be, but just to illustrate what's going on, the magistrate cannot finally dispose of a case. What they have to do is give their recommendation to the district court judge, who will then sign off or not. So the magistrate, this happened one time years ago with this actual situation with a, all right, this happened in an actual situation in the district court in San Jose, where the magistrate wanted the motion to dismiss denied and wanted a hellacious amount of money in sanctions. I'm talking like $25,000, $30,000, $40,000 for a motion. But they couldn't deny it themselves. They had to make a recommendation, this recommendation to the magistrate, and from the magistrate to the judge, and the judge didn't accept it, which is extraordinary. So there could be a situation where a lower level judge cannot grant the motion to dismiss. I'm not familiar with that at the local level. I've only heard about it in the federal courts. So keep that in mind. But hey, it's great that Chris was able to get something tossed out, even if it was just the fact that the police officer didn't appear. And it could be one of these things where just challenging it was all that was necessary. That didn't need any merit. So hey, that happens. So I don't want to turn that on. Anyhow, this has been episode 79 of the No State Project, live commercial-free from the fortified compound in Mesa, Arizona. I want to thank again the support of the show. I do appreciate it. Jan, the Dude, Don, Nelson, Eyal, and of course, Bill and Dan up in New Hampshire. If I've said something on the show that you disagree with it, call into a live broadcast or sign up to the forum. I will not respond to YouTube comments, and I don't respond on Facebook. Won't do it. Just won't do it. Waste of time, and I have to, remember, that. Look, go to my Facebook page, and you'll see. You can probably follow my comments, and you can see. I can't imagine the crap that's waiting for me, but I have to do. I have to do the right thing and just let it go. And again, the rationale behind why I don't respond to YouTube comments is because it's not worth the time. Confront me in real time, but on YouTube, where you can get cancer reading that stuff. Look, it's legendary. Everybody knows you don't go to YouTube for a rational discussion, but you go to markstevens.net and sign up for the forum. Yeah, then I will respond there. Again, my name is Mark Stevens. This is the No State Project for, it was September 12th, 2018. And not only should we be remembering the 3,000 almost thousand people that were lost in 9/11 18 years ago yesterday, or 17 years ago. We should also remember the over 1 million people in Iraq that lost their lives based on the lie of the Bush administration to launch that war. And I don't know how many hundreds of thousands of people have been lost in Afghanistan. The longest war in United States history, launched on a lie, a provable lie. So let's remember all of them. And I think it's great that this officer something is being done. So police officer Amber Guyger. Gosh, I hope she gets fair trial and is put in prison. But hey, we'll be live on Saturday. So till then, salud.